So today's class, I would maybe slightly change the title, but we're going to look at the question of application, which has been the big kind of glaring hole in the course so far. And because it's so important to the Jessup, I kind of wanted to wait until you had more of a grounding in international law, which you've hopefully got from the classes in the morning, and some more of an understanding of just, I mean, we now know how the Jessup proceeds, how the memorial works, but this is actually more about legal argument in general. It's more, I mean, it is more academic, and it's more about how one approaches a legal argument. Distinct from actually how the Jessup works, it's more about a kind of general way of thinking. We'll unpack it a little bit in a minute. There's two things that hung over from yesterday that I just wanted to address. So there was some discussion on whether there's any way to get better at legal writing. And I've added a couple of books here that I've had recommended to me in the past. So the first two are full texts. The third one is a journal article that spawned the book that's above it. I'm going to send the slides out, by the way, to Lena tonight so that you can have them. That article is hyperlinked, so you can read it. I'll admit I haven't had a chance to read it yet, but considering the guy has made 5 editions of the book on the basis of that article, I presume it must be of some quality. And underneath there's also a YouTube account I found called Written Legal English. Again, I haven't looked at this, so I have no idea exactly how good it is, but I can have had a skim through the titles of some of the videos, and it seemed useful. It talked about how to be concise in your language, how to be clear, how to break down kind of difficult terminology into something that is easy for people to follow. So it's probably worth, if you're kind of interested in these things, have a look at sort of resources like this. The other thing we didn't really have time to talk about, and we'll kind of return to this at the end of the lecture, or the latter part of the lecture, but it's one about the question of sources and how exactly what kind of sources you want to cite in a legal argument, both in the written and in the oral. Now, as Sergey would have taught you yesterday, and as we looked at a little bit on Monday, the sources of international law for the ICJ are prescribed in Article 38(1). There are treaties, there's customary international law, there are general principles of civilized nations, very problematic language, and then finally the writings of highly qualified publicists, which also kind of covers international tribunals. In theory, there's no hard source, no hard hierarchy of law. Custom can sometimes supervene treaty obligations, sometimes treaty obligations will undo custom. There's no hard and fast way of looking at these. There is normally an expectation that those two will be more important than general principles or the writing of academics, purely because, as we've touched on throughout the week, and will definitely be a focus of today's class, international law is expected to be a law that the states have agreed to. So normally they don't like looking at things like principles or things like what academics have written, because that suggests that perhaps the states haven't had a hand in drafting it. In practice, the picture is a little bit more difficult. I think particularly if we're talking about the practice of the Jessup. As we'll talk about at the end of this portion of the class, you need to remember that you're pleading before the ICJ, and the ICJ is a specific institution with a specific function, a specific understanding of its own function. So a judge on the ICJ has an idea of what their job is, which would be different to a lawyer or the head of a government, or a Supreme Court lawyer in a domestic institution, or a criminal court judge, or the point is just to show that the ICJ has a different way of, or has a different role, and that changes the way that it looks at legal questions. We'll unpack that a little bit more later on. But the reason I bring this up is that when you are writing your memorial, in my head there's an implicit hierarchy. The ICJ cases are probably the best source that you can cite. Because if you can show to the ICJ that they've previously ruled on these questions, or rather have given rulings that are applicable to the question that is in the compromise, it's not so difficult for the ICJ to follow that case again. By comparison, if you cite a textbook, I mean, that's fine, but if it's never been affirmed by the judges, there's no reason why the textbook is necessarily safe law. It's more, the judge has to do more thinking about whether it's correct law, let's put it that way. If you present an ICJ case that's previously happened to the ICJ, then the ICJ, the judge on the bench can say, well, we've done this before, that's fine, it's accepted law. Similarly with citing other tribunals, I mean, citing the European Court or other courts is good because it shows that they are, real legal bodies that are passing these judgments. But on the other hand, those courts have different treaties to interpret. They have different views of their own function. Different people view their function differently. And the ICJ will often have to think whether it can actually take the legal reasoning from one court and apply it to itself. So all I want to say sort of right now is that when you're, particularly in the written, but also in the oral, you should be sticking to your primary sources. So try and avoid academics' arguments. If you're going to use an academic paper, steal their citations, see how they reason through them, and then use that reasoning yourself and cite those cases. If you cite the paper, it just doesn't, at least to me, if I'm a judge on the bench, it doesn't feel convincing to have someone say that somebody published an article saying this is the way that drone strikes should be treated. That, to me, as an ICJ judge, is a million miles away from the ICJ saying that this is how the law works. At best, if you are going to cite text, there are certain classic textbooks on treaty law, on international law in general. Some of these do have a kind of recognized status of being, what's the word I'm looking for, reliable, because international law is such a difficult system to get your head round. Practitioners will often grab for a textbook, and that means that the textbooks that are kind of shared throughout the legal academia, those, might be able to be cited as kind of the standard doctrine of a certain issue. We'll unpick this more as we get into the actual content of today's class. I just wanted to raise the issue that when you're starting to draft your memorials, make sure that you are focusing on sources that are most important. So focus on judgments, focus on things from the UN or from other international organizations, things that states have said, state practice. Try and ground it in something that's real rather than a nice argument from an academic somewhere. So, what's the next slide? Okay, we have a blank slide for some reason. That's not good. Today's lecture, I want to kind of try and take us through what it actually means when we say application. What the process is that we have to go through to take a 30-page document of facts and all of the international law in the world, which we've then researched and drilled down to the relevant rules, but nonetheless there's still a whole body of rules that we have to consider, and how we mix these together in a way that makes a convincing argument. And to do so, I'm going to start with a kind of more practical discussion of this, and then go into some more theoretical debates or theoretical writings that discuss how some of these questions tell us things about the way that legal argument is structured. And from there, I want to try and show you how we can understand what a good legal argument within the context of the Jessup is. I want to admit a couple of caveats first. First of all, this is definitely my approach to the Jessup. It was not clear I'm more academically minded than legally minded. So this is not a universal approach. This is, if anything, this is my Jessup manifesto. On that point, I'm still working some of the parameters of it out in my head. So if this is a little bit rough, a little bit complicated, a little bit confusing, that's fine. The hope is just to get you to think about some things and maybe take one or two ideas from it. And by me talking this through, I might get a better idea of what I'm talking about, so that if I talked about this in front of people again, it will be less confusing the next time. The third thing is that as I said, lots of people will not agree with this, and that includes judges. I have met judges who have said, I remember judging with one guy in Brazil, and he said, "Oh, I'm a black letter lawyer. You know, I like what the law says, and I like to do what I look at the treaty. What does the treaty say, and we do the treaty." Now, as we're going to go through, and hopefully I'll show, I don't think that the premises of that argument are correct. I don't think you can just find what the law says. I don't think you can just find what the facts say. And in applying these two things, even if you believe that you are stripping away normative concerns, policy concerns, it's never really possible to make such an interpretation neutrally. But the point is that other people will tell you different ways of approaching this, the Jessup in general. And I just want to say that those ways are not wrong, but they have their own problems. The fourth point I want to make, there was one more, is that while I want to point these things out and kind of provoke your way of thinking about legal issues, this isn't the way that my brain works all the time when I'm doing the Jessup. Obviously, when you're actually doing the Jessup, you're reading the cases. When you're standing up in front of the court, you have your arguments prepared. You're repeating those arguments, repeating the important parts of the judgment. I'm not thinking about critical theory. I'm not thinking about French post-structural approaches to language. This is more of a thing for reflection, I think, between pleadings, or when you've got one draft of your proposal of your memorial, or even when you're meeting and discussing with your opposing people in your team about how legal issues work. Some of these things can be useful, I suppose, thought exercises to kind of escape some of the traps. It doesn't mean that you have to think this way all the time. In fact, if you do that, you definitely won't be able to make a coherent argument. It will just lock your brain up. But it can be useful to use this as a way to test arguments. And one final point, this is something we also talked about yesterday, but obviously the scoring, particularly in the oral rounds, places a greater emphasis on how you speak. So to some extent, the application is actually not that relevant to being great at the Jessup. Some people have not terrible, but only a basic knowledge of the law, a basic knowledge of the facts, and the putting of the two of them together is not that great. But they can stand up, they can speak in front of a judge, the Q&A is good, even if what they're saying is rubbish, at least they sound convincing, and for some judges they will still get very high marks. So it's also worth bearing in mind that this is only a very small part. However, I think that convincing legal arguments do make the rest of the Jessup fall into place. If you understand the law, and you understand how your arguments fit together, and you understand the push and pull of legal argumentation, it will make you more confident. So while this stuff might seem kind of like a small section of it, I think if you can nail this, it makes all the rest of the pieces fall into place. Because then it makes it much easier to believe that you are an international lawyer, and that you do know what you're doing and what you're saying, and that you do sound convincing and you sound like an expert. I think people that have a lower, some people can just blunder their way through and still sound really convincing, and that's a skill that's great. It's a skill I don't have. I have to know what I'm doing before I can argue these things. So that's a big introduction, a big caveat to what we're going to do today. And before we actually start the lecture, I want to just try an exercise to get us thinking about things. So I've put two things on the board, international lawyer and drone strikes. Let's start with this. So we all know that the Jessup is a competition about international law, and that we are international lawyers within that competition. But what exactly do you understand this phrase to mean? International law or international lawyer? What is international law for? What are international lawyers for? Who are these people? What do they do? So just kind of, I don't know if you want to discuss this in groups or just do call-outs, but what kind of key words does this make you think of? Are there kind of flash words that international law makes you think about? And I don't mean, not genocide, not active aggression, not very specific things, but in general, what is this thing that we've been talking about all week? Knowledge, okay. Interesting. What kind of knowledge?
The legal implications, the knowledge of facts, how to apply the legal knowledge to the facts.
Okay, So we can maybe call that professional knowledge. That's an interesting point. There is a way of thinking about issues, and it's a way of speaking about issues and knowing how to speak about these things. Anything else? Dispute resolution, good. Okay. Anything else? I mean, more big normative things. What is international law? What is international law about?
Relations between entities.
Oh.
International relations.
Okay, so international relations. Good. Anything else? It's terrible handwriting, I'm sorry. Responsibility, okay. Responsibility for what? Responsibility for brackets wrongful. This is a good. So what? Let's take this further. What is a wrongful act? I don't mean the legal definition. I mean what are some wrongful acts? What kind of things in international law? Breach of sorry? Obligation. Okay.
And attribution.
Obligations. And yet someone said attribution. But what? Like you're being too clever. I mean that's good. It's good that you know these things. But what obligations? What are we actually talking about? Okay, so the international relations. But what rules? Okay. Good, but what rules? I mean I'm not.
Legal rules.
Legal rules, yes, but. Okay, let me put it this way. You turn on the television and you see something that mentions international law. What kind of news article are you likely to see? What is the subject likely to be of international law in the sort of public sphere? Less academic, more normative, yet. Like
In general,
war and peace, thank you. Here we go. So things like war and peace are the kind of, I would say some of the crucial things that people have in their mind as international lawyers. Maybe not. If everyone else has gone for this very doctrinal explanation, that's interesting. So war and peace, are there other things that we think about international law as meaning, as governing? So what about trade? Do you think trade has international law implications? Did someone say no, or was there an answer to that? No. Okay. Trade. Does somewhat like or. Okay. So yeah. I mean. So yeah. There's things like WTO law. I mean. Okay. This is interesting. It's interesting that you've not jumped to the conclusions I expected, and that's to some extent good. We'll get into that. I mean, on a more personal level, why are you all interested? Let's go back a step. I've actually forgotten this. Raise your hands if you've studied international law before this week. Okay, so we actually have fewer people doing it. That may explain. Okay, that may explain some of the reluctance. Okay, allow me to put a little bit of my own personal story. I think my first awareness of international law, and I'm a little bit older than you, so maybe this is something that you won't remember so clearly, but for me it was the Iraq War. The Iraq War was the first time where I realized that international law was a thing that was important. It was suddenly cropping up in debates about whether the war was legal or illegal. And, you know, certainly the argument seemed to be that because it was illegal, it was a thing that shouldn't happen. Or rather, because it was a thing that shouldn't happen, it was illegal. We can discuss how those two questions interrelate. And I think I would imagine for most people, and particularly most people in the Jessup, and you will hear this in the Jessup when you go to the competition, and people talk about what international law is, why we do the Jessup, what the Jessup gives back to the world. It's these kinds of ideas of kind of peace and security and international cooperation and working towards a better world and all these kinds of ideas. What I think is interesting that you've acknowledged is that international law is not simply a normative project or a moral project. International law is not just something that causes peace. It is actually a professional knowledge, it's rules, and there are, you know, I think people sometimes have a habit of seeing the international lawyer as a superhero. And they kind of forget that there are international lawyers within the government, there are international lawyers within the military, there are international lawyers, legit, you know, I mean, every case that comes before the ICJ means that there's a dispute. And if one side is legal and one side is illegal, there are still international lawyers who are advocating for the illegal position somewhere. Trump has international lawyers who told him he could do what he did. Maybe. No one's quite sure of that. Tony Blair had international lawyers. So, the reason I did this was to try and pick apart the normative thing, but you've almost second-guessed me by treating it only as a discipline, and that's interesting. So we'll pick that up in a minute. Let's go to the other side of the board. So drone strikes has been the thing that we've been looking at all week. Again, trying not to think of it as lawyers, but just thinking about drones as a thing. What are the questions about drone strikes? Political, moral, ethical, practical. Why do we have drone strikes? What do they do? What do we think about them? What are the questions? Even without thinking about law, I mean, what is a drone strike? Can someone give me a basic definition of what a drone strike is? You've all been reading about it this week, so what is a drone strike? Or what is a drone? Let's even just ignore strike. What is a drone? What is drone warfare?
Drone strike is a targeted killing.
Targeted killing? Okay, good. So what is targeted? What does the targeted mean in targeted killing?
It means that the killing is discriminate on its target, so that the weapon can discriminate whether this is the combatant or a civilian.
Okay. So it can discriminate. So what is that in comparison to? So when you say that targeted killing can discriminate, what can't discriminate? What are you measuring that against?
Nuclear weapon.
Nuclear weapons, okay. That's jumping to the biggest possible comparator, but nuclear weapons, yep, they absolutely cannot discriminate. Anyone else got? How else do you understand drone warfare as a?
It's a new technology which acting without people near it. Man combatant can use it automatically on another part of territory or even from another state.
Brilliant. No physical soldiers. It's a new technology. It's can be cross-state, or a truly international weapon. So now taking it to a more moral state, why are these things important? I mean, why do we want to be able to discriminate between targets?
Because if we compare targeting, killing, and technology, we will say that it's without humanity. Because combatant who is physical, he has some physician feelings, and for him or even she, it's hard to kill another person because he understanding that he or she is or its civilians is alive, has feelings, has family, and so on and so forth. With the modern warfare, you decide this problem because states are not nervous about personal feelings of their soldiers.
Brilliant. I hope you're the applicant. That's a very interesting argument that we'll pick up. Yes, there's an idea that the drone warfare removes something, removes two things from warfare. I think there were two ideas, if I might pick apart what you said there. There are two ideas that underlie it. One is that it makes it easier to kill because you don't have to face a person in battle. You don't have to actually look the person in the eyes as you pull the trigger. God, this is remarkably bleak imagery for 11:45 on a Wednesday morning. Easier to kill people, but there's also a kind of question of whether warfare should be fair. That you should you be able to be attacked by someone that you can't actually see? Yeah. So there's a slight element of, I mean, fairness is perhaps the wrong word. War obviously warfare, because it's such a kind of gruesome thing, but it's also bundled up with a whole other bunch of interests. It becomes difficult to unpick language like fairness. But yeah, there's an idea that you can't see the person. The drone warfare now does. It's changing the way that we fight wars. Yes?
A huge role of intelligence.
Intelligence. Good. So that's an interesting one. There's also...
They provide the information, and the operator, basically, he pushes the button.
Yep. And we can add, because I've read the memorial, or the compromise, we can add quality of intelligence is definitely a question that we have to answer. What about this idea of targeting, though? So I agree that on the one hand, warfare means that you're no longer seeing the person. But what about this idea, you mentioned discriminating between civilian and combatant. What can you unpick the moral implications of that?
Whether it is the lawful use of force,
Okay.
corresponds to the principles of international humanitarian law,
Yep.
whether the principle of proportionality is adhered to.
On a more basic question, though, why do we not kill civilians? Anyone? I mean, might sound like a very obvious question, but why do we not kill civilians in warfare?
Because they are not engaged in the conducting of the hostilities.
And they're not to blame.
Okay, good. So innocence.
It is bad.
So now you're starting to see the.
Simple things.
Yeah, you're starting to see this is all of the debates that I mean, the law of armed conflict is not something that simply has one focus. So there's all this kind of terminology about discrimination, not attacking innocents. They're not to blame, but the fact that you can now bomb a country from from thousands of miles away by not putting your troops in danger. So questions about how warfare should be conducted, whether a person who's going to kill another person should put their own life on the line. I mean, even if you go back to, now I'm going to hold my hands up here and say I'm not a humanitarian lawyer, so if I get this wrong, Sergey, I apologize to Sergey because he's more of an expert in this and he can see you right on Friday. But humanitarian law grew out of in the mid 1800s from people like the Red Cross. And they brought in a number of these ideas of not killing innocents, and mainly the idea of not killing innocents. That was one of the main kind of first things. Not killing innocents, and then sort of treatment of prisoners of war, issues like that. Before those rules were in place, it was perfectly legitimate to kill innocents. There was an idea that if you killed the civilian population of another state, the war would be over quicker. If you indiscriminately slaughtered everyone, then eventually the king would have to give up, because his population would be dead, or he would be losing his authority to even command people to go into battle if half of his territory were murdered. So these ideas actually, I mean, they have a historical pedigree that they develop out from. We don't need to go into the history of humanitarian law. The point was just to try and draw up that there are always competing interests within the project of international law in general, and specifically within the kinds of legal contexts that we can talk about, legal regimes we can talk about. There are always interests from each side, from different parties involved, both of which seem equally justifiable. I mean, so for example, we don't want civilians to die, but we also don't want to send soldiers into battle to die unnecessarily. You don't want to send your own troops in to die. So one way of thinking about laws or one way of thinking about legal argument is how we temper some of these conflicting issues into something that becomes a coherent argument. So let's try and pick through that today. So for some reason there's a blank slide. So the slide, unfortunately the slide that's missing explains what this slide is about. Yeah, so as I sort of explained at the start, the idea is to take a kind of more critical view of how we construct a legal argument and try and work out how to gain a foothold over all these sorts of inconsistencies. And as I said, many judges, many people within the Jessup will tell you that they just apply the law, or that they just have an idea of what the right answer is and they want to see that answer replicated. Whether or not judges take that approach, I think it's problematic for you students to take to treat the Jessup in that way. It's Jessup for 4 reasons. One of them is that one of the biggest mistakes that I see competitors make is that they will try and research more law as if there's a right answer that they can find, as if they just keep digging down that they'll find the one treaty that actually subsumes the entire case into itself. And then if they are challenged by their opponent or by the bench, or even by an internal inconsistency within the compromis, they struggle to answer that. They struggle to explain how their argument can move around these kinds of obstacles, because for them there's a right answer. I understand why that's a tendency. I mean, it's the way that you're often taught, particularly in the early years of law school, is just to learn the case, apply the case, look for the facts that are the same. And this leads us to the third point. The second point. The Jessup is not structured that way, and we'll look at some quotations from Ilsa's own guide. But the Jessup is deliberately written both so that the facts are ambiguous and that the law is not settled, and that even where there is settled law, there should be some space to challenge it, or at least the settled parts of the law should be the same on both sides. Both of you should have a certain number of arguments that are strong and then arguments that are weak. And it's for that reason I think people that take the stance of, well, I just apply the law, kind of misses what the Jessup is trying to do, which is give you a real world problem that is not solved, and seeing how, giving an infinite number of monkeys, an infinite number of typewriters, so giving all these students around the world the same legal problem and seeing how they crack it. The third point is that it allows you to look through these questions of difficult law or difficult submissions, and hopefully gives you some hope in points where you think you have just an unwinnable argument. And finally, although none of you picked up on this today, but it does hopefully puncture through some of the what I call the utopian strains of the Jessup. Sometimes there's an idea that international law is always going to produce a good outcome, and while there are good reasons to believe in that myth and to work within that myth, you also have to understand that it is a myth and that it's not one that is borne out through legal practice at all, or through international relations at all. But you all identified it as a professional knowledge anyway, so never mind, morality is not a question in this. Let's just skip on. So in the words of Chief Wiggum, what I'm trying to do is break you down, rebuild you as functional members of society, break you down again, take a break, and then if there's time, rebuild you once more. Okay, so Iraq, we went through this. The conclusion is predetermined by the compromis. The issues and the rules, as I understand it, should be the same roughly for both sides. They may be put together differently, but you are still dealing with the same issues. So we need to focus on what application is. That's the thing that distinguishes applicant from respondent, and good pleaders from bad pleaders from great pleaders. What is application? On a very basic ground, it's law plus facts. However, neither of these concepts are as self-evident as that formula would have you believe. Because for one, if they were, there would be no argument to be made. If the facts clearly support, if the law was clear and the facts were could clearly show how the law applies to them, then there would be nothing to argue. So as we said, the Jessup is constructed in a way, and if not all of reality is constructed in such a way, that makes those kinds of determinations impossible. So Martti Koskenniemi, who we'll touch on later, he's a professor in Finland. I'm a bit of a fan. So he identifies this as two kinds of interpretive issues. There's problems of content, which is understanding in abstract what the content of a norm is. So exactly how a treaty provision is interpreted, what freedom of the high seas means, what genocide is, trying to work out that norm just on its own. The second problem is a problem of application, so that's taking facts and legally qualifying them, understanding how we see factual circumstances within a legal argument. And as he notes, there are no pure problems of content or of application. When we think about the content of a norm in abstract, we're always trying to think about what that norm is supposed to achieve. And therefore, there must be certain factual predicates, factual foundations that understand what we think genocide is supposed to do. Similarly with application, when we legally qualify facts, we are inherently saying something about the norm to which we're trying to make them fit. So we're either saying that the use of force, the threat of force, let's take the Corfu Channel example, does the threat of force cover military demonstrations, like when an army will march past a border, for example. That says something about what when we qualify those facts, we're thinking back to the norm of what we think the norm is supposed to achieve in abstract. So it means that in any problem-solving situation, we need to determine both of these things kind of simultaneously, and the two, it's impossible to split the two things apart. The interpretation of both of these questions is the same, or not the same, but it has to be carried out at the same time. What does it mean in practice? If you have a difficult argument, there are at least two ways, very broad ways, to start thinking about how to get around a difficult problem. One is that if the law seems settled, if there's a legal case against you, then you can try and focus on showing how the facts are not the same as the foundations of that legal norm. So for example, let's take genocide. If there's a, well, no, let's not take genocide, that's a more complicated one. Let's take Corfu Channel. So in Corfu Channel, they said that the ships going past the Albanian, through the Albanian Strait, it was a large demonstration of military, of British Navy ships. And the court had to ask whether that was a threat of force. And they go through a number of assessments, and they say that while in theory it could have been a threat of force, that the circumstances, they go through a number of factual circumstances that suggest why it would not be taken as a threat of force in violation of the UN Charter. Sorry, not the UN Charter. I'm mixing that case up. But not a violation of the threat of force. There are certain facts in that case, when you read it, that explain how the court got to that final conclusion. There are certain facts that they stress, they explain how they understand the norm and the facts intersecting. So when you find a case that seems to set out a legal test, what you should do is compare whether the facts can be distinguished from that case. Or if you want to apply the case, you need to find out exactly what the facts were that led to that legal conclusion and identify them within the compromis itself. This is, of course, a matter of interpretation in and of itself. You have to read the judgment, you have to try and guess what exactly the court was saying, why exactly the court made a certain kind of decision, and then explain how your facts do or do not fit that framework. These will be that's often the sort of question that a judge will ask you. So they will say, yes, this case exists, but what were the relevant facts in that case? And how are those relevant facts also here or not here? Now again, what we know about the Jessup, because the Jessup is written ambiguously, often there will not be clear facts, or there will be some facts that suggest the test should apply, and some facts that suggest that actually the court may not have taken that conclusion. The second question is that if the facts do appear the same, and that's more unlikely, but if the facts do appear substantially the same, one can try and argue that the legal rule itself has changed, or the way that the legal rule itself, the way that the legal rule was interpreted should now be interpreted differently. There are a few ways to do this. Customary international law gives you one. Obviously, hopefully Sergey, I trust, has covered this, customary international law, how custom is formed. But customary international law is obviously a more malleable and more reactive source of law than hard treaty interpretation. It's something that changes depending on how states are acting and what states believe their legal obligations are at a given moment in time. So one can try and argue that a new customary international law norm has developed. They can argue that a norm has changed. They can argue that a norm has ceased to be in effect because it's been repeatedly breached. So there's one way of approaching it. There are also the question of if you have conflicting treaty obligations, how those are to be mitigated. Some of that is laid out in the Vienna Convention on the Law of Treaties, but if you read works by Jan Klabbers, has a really good book on treaty law where he talks about a number of the problems of trying to determine exactly what a conflicting treaty obligation is, how exactly these should be harmonized, whether there's a hierarchy of treaty obligations, for example, whether human rights obligations are more important than trade obligations. There's a whole number of ways of challenging how exactly the law is interpreted. But the point is just to say that if you find a judgment, it's worth thinking. It's worth thinking about that judgment as a single event, and not to treat it so hard as a kind of hard rule that can be applied as if, like the Ten Commandments, you can just fit it onto law, onto facts. Sorry. It can be more helpful to look at exactly why that event occurred, why that judgment was reached, what the relevant legal and political debates and policy debates were that were going on at the time, and how exactly that differs from the compromise, or is the same as the compromise if you want to draw an analogy. In practice, of course, taking as we did that the problems of content application are intertwined, both of these elements can be argued together. So one can argue that certain factual requirements were laid out in the law that are not present here, and also that law has changed. Or that the way that we look at these facts now has changed because we understand that, for example, that human rights has changed the way that we view the rights of individuals and states, or how we treat the treatment of individuals by states in certain cases. I'm aware that this is becoming kind of abstract and difficult. Is everyone roughly following what I'm saying here? If there's one thing if there's a mantra that you have to repeat through your head throughout this lecture, it's that there's no right answer. And that if you try and find a right answer and you try and treat the case like it has a determined right answer to be found, you'll drown. It won't work. It doesn't mean that there aren't important bits of law to find. It doesn't mean that there aren't things that you have to argue. It doesn't mean that there isn't a correct way of arguing. But the point is that there's no determined outcome. You're not going to find the case that says that these actions are legal or illegal. It just doesn't exist. And even if it does, there should be ways for you to challenge it. So let's try and go through it. When you're making your arguments, this is maybe the second big mistake that you see teams make. So they've understood that they have to challenge the law, and they stand up and they say, Your Excellency, we shouldn't follow that case, we should follow this other case. And it just so happens the other case that they want you to follow is the one that helps them, that comes to the legal conclusion that they want, and the other case helps the other team. And when you try and ask them to explain why we should depart from that case, why we should pick a new case, why we should take their treaty interpretation as more authoritative than the applicants, the respondents, whoever side they're on, often they struggle to answer that question in any way either. So what I would suggest is trying to always connect your arguments to kind of broader foundations of international law. Now I'm aware, and I forgot this, that most of you don't have a background in international law. So I'll try and give you a very, very brief, rough history of international law, or at least the way that international lawyers believe the story of international law to make sense, which is that international law came into being at the Peace of Westphalia, which stopped the 100 Years' War, and it set up the idea of sovereign states, which were not to be, you couldn't take territory from those states, that you couldn't, well, you could at the time, you could do conquest, but these states were individual political units. They could have relations amongst one another, but internal to the state, the actions of the sovereign could not be challenged by other governments, other kings, other states. And this foundational idea of state sovereignty has continued. It remains the kind of founding myth of international law, is that we have, there's this idea of states as billiard balls, that there's something that they crash into one another, but you can't actually see what's going on inside. There's a domestic sphere that the international law, the international field, is not allowed to look at. Whether that's true anymore is probably not correct. I mean, we have human rights, we've had the development of decolonization through self-determination, we have prohibitions on genocide, we have Hughes Kogan's norms, which are kind of acts that states should never do. So the question of whether the state itself is a kind of sealed vacuum of which international law can't look at anymore is not really true anymore. That doesn't mean that this doesn't have a power as an argumentative foundation. What does all this mean? This history. When you want to push the court to make a different kind of decision, or when you want to make the court engage with what you're saying, it can be useful to try and tie your argument into these foundational things. So not that your argument helps your state, or not that your argument was what your state was doing, but actually that your argument is the only argument that upholds human rights, or is the only argument that properly takes territorial integrity into account, or that is the only argument that would prevent the international order from falling into war. You don't want to be quite as baroque as that. You don't want to stand up and say, I am here to save the world. My legal argument will solve poverty and famine. And obviously, you don't want to go that far. But if you can get a sense of what the main, and this is what I tried to draw out here. If you can get a sense of what the main purposes of international law are, what the beliefs of international lawyers, international judges, international actors beliefs are, and you can make your argument seem consistent with those foundational qualities, it at the very least makes it harder for the bench to challenge you, or at least takes the bench down to a level of debating what these things mean. And at some point, these are meaningless concepts. I mean, they're just kind of big foundational ideas that allow us to talk about international law in a way that is recognizably legal. But we're sort of jumping ahead to the more difficult stuff, so let's try and keep it on track. An obvious but important point. You need to believe your own arguments. You can't stand up and say, our government got it wrong, this was illegal. You can't do that. You can't say, oh yes, there was this advice at the time and it was wrong, but actually, if we thought of it this way, if you just look at it this way, it was still legal anyway. This is why I stress the idea of thinking that you are the legal advisor for this country, that you've been there every step of the way. When they've legitimated the drone policy, that you were the one writing the law and signing it, passing it through Parliament, that when they came and said to you, should we launch this drone strike, you were the one that signed the legal advice that said yes. And trying to think back to how exactly at each stage of that event you found the legal justification for what happened. Because again, so often you will have teams stand up and try and give a retrospective analysis of why it's legal. they'll stand up and say, well, looking at it from today's perspective, it's legal. But it fails to grasp exactly how all these events occurred on the back of one another and how they developed into the legal problem that is before the court today. So believe your own arguments. Believe that you have acted legally, that your state has acted legally throughout the compromise. You cannot compromise on that, and there can't be exceptions. Unless, of course, the compromise says you can take an exception, but that's rare. And you cannot concede arguments or ignore problematic actions. You can't just ignore the fact that certain drone strikes have gone wrong. You have to work out how all of that is still within the realm of legality. Or if you did accidentally breach the law, how exactly you've mitigated that, or what your state has done to change the policy, for example. Okay, we can skip through this. So, as I said before, the idea of application suggests that it's law and facts, and that these are two things that are difficult to extricate from one another, and that moreover, these two things are not self-evident. The facts are not something that everyone reads the same way, and the law is not something that has a determined content either. Not only is the law itself potentially indeterminate, but also as we move through time, previous legal decisions can be challenged by the context in which we are now interpreting them. Here, okay, I thought these were earlier on, this is where they've been hiding. So the White and Case Jessup Guide acknowledges as much. On page 2, it talks about how the compromise is written, and it says, Jessup competition is intended to be a relatively fair match between the two arguing sides. Jessup judges want to focus on your team's ability to prepare and present good legal arguments rather than decide which team has the winning legal argument. We'll come back to that in a minute. Therefore, most Jessup problems are written with the goal of balance. In order to maintain that balance, certain facts are included or omitted so that the issues do not overwhelmingly favour one side. Often the facts are drafted so that there's a degree of ambiguity. The goal of the authors is to avoid clear answers as to which side is right, thus allowing both parties to use particular facts in their favour to argue their case. So if you keep that in your mind, the Jessup is not written in a way to give you a right answer. We sort of talked through that, so naked facts. The other thing that makes the Jessup different to a real legal issue is that we all have to work from the same textual document. So we all have only the 30 pages, and that's the only thing we can look at. There's no real aplia, there's no real respia, there's no way we can get more evidence, there's no way that we can go and send a fact-finding mission. We can't look at the political actor himself. We can't ask whether the president is we can't ask if President Fudge is a Trump or a Marine Le Pen, or we can't, there's no reality to base these things on. We only have a written text that we all have to interpret in different ways. Now, there's a whole school of French philosophy and critical theory and literary theory that discusses how we can deal with this, which we don't need to go into because it's far too complicated, but is very interesting and discusses some of the questions of when we read something, how we determine a meaning from a text, what we understand the purpose of a text to be, what we understand the way that we understand contextual clues for meaning. There's no need to unpack all of this. The point is just to say that in a real legal dispute, there would be a broader context from which parties could draw on, the court could draw on. In this case, we only have this ambiguous document. We only have this unclear, incomplete sense of the facts. And that, again, is just to stress that it therefore means that we have to grapple with the different meanings that can be interpreted from the same 30 pages. We have to understand that the bench will interpret it differently to the applicant, will interpret it differently to the respondent, will interpret it differently to the applicant from the French team, will interpret it differently to the respondent from the American team. And we need to create a convincing legal argument, we need to work out how to grapple with this multiplicity of meaning to make something that sounds convincing. We'll get to that question more in a minute. Oh, is this broken? Have I broken the thing? Oh, I turned it off. Nope. Oh, here we go. Hang on. Examples from the compromise. So here are a couple of kind of factual questions that I thought might be from this year's case, which would be relevant to looking at. So, for example, what is a terrorist? Now, I'm not saying that there aren't legal definitions of some of these questions as well, but the point is more engaging with the factual chain of events or the factual elements that need to be present for us to say that someone is a terrorist. I mean, there's this common question of, what is a terrorist or a freedom fighter? Or one man's terrorist, another man's freedom fighter, sorry. And these will be the sorts of things that will be the foundations of your legal argument. If you want to justify, certain kind of action in response to terrorists that the law allows you to take against people within that designation, then we need to deal with the facts that create that kind of person, that kind of subject. There are also questions of what kind of threat do these people pose. The point is just to draw out that within, it's very easy to think that when you read the compromise that the compromise is, and particularly because we've been stressing that you can't challenge the compromise, it's very easy to read it as a kind of flat document that gives you hard facts. And it's just worth thinking about exactly what you could do with some of these terms, how exactly some of the constructions of narratives or events can be challenged or put to different purposes or recontextualized or reformulated to present different kinds of ways of looking at the image. To sort of demonstrate this, Koskinen often does the seeing eye trick of the duck that looks like a rat. I'm going to try and draw this and it'll be terrible. I'm so bad at art. Is that a duck or a rabbit? Neither is the answer because I'm a terrible artist, but the idea is that you can look at this picture from different perspectives and see different things. So you could see the bill or ears if this is the head, or I'm not even going to try and justify that drawing. But the point is just to take some of these questions more, to cast this kind of critical eye when you're dealing with the facts that are given to you in the compromise. We discussed that, aren't some of the questions legal? I'll zip through this quickly. So the same question with the law. There are outside things we can look at. There are cases, there are treaties, there's state practice, there's a reality that we can compare these things against. Nonetheless, there are two main obstacles. One is that the Jessup is drafted in such a way that it's drafted in such a way that there is no totally settled answer, and in any case, the law is never fixed, as we've talked about. So we'll pause here and then we'll take this up because I think the camera's about to run out. So we'll pick this slide back up in 5 minutes. We'll take a quick break and then see you back at 25 past and we'll zip through the rest of this. Okay, so we've kind of got stuck. I realize the way I've structured this in trying to separate the simple part from the more philosophical question is just kind of trapped us in a loop. So I'm going to try and get out of this loop, go through the remainder of the slides which are a little bit more practical, and then we can maybe try and at the end discuss how you've understood some of this, how you've understood the last 3 classes, and if there's anything else we can kind of talk about or clarify before tomorrow's session. So where we left it, just that these 3 kind of ways I identified indeterminacy in the law, or ways that the law can be challenged or changed, or that the law is not clearly applied. One is the facts, how we characterize facts. One is on the context and the time in which that original law was made, or that original legal interpretation was made, and how that has changed from today. And then one is in the language of the law itself. Now this, to some extent, subsumes the other 2, what is factual and what is temporal. But there are certain words within international law that themselves have no defined meaning. They never can have any defined meaning. So for example, this is the definition of the right to self-defense. The right to self-defense must be satisfied in the conditions of necessity and proportionality. Those are inherently value judgments. Whether something is or isn't necessary is a question of how you understand the motivations for the thing that has occurred, the thing that has occurred, and the effects of that thing. And you have to, and proportionality is the same, you have to assess what the values are that you're weighing against one another, the groups of people who you're weighing against one another, the interests that you're weighing against one another, where exactly the line between these two interests should be set, whether there should be a margin of appreciation as the European Court uses. The point is that there's no thing of proportionality. We can say what a treaty is with a relative degree of certainty, but we can't say what a proportionate action is with a degree of certainty, except without reference to other kinds of cases, and then we come up with the same kinds of problems. So we can go to a previous case and say, here, this was a proportionate action, but there are a number of ways that you can challenge that case on its own merits, or the citation of that case, and that leads you to the same problem. What kind of values are we balancing? Whether the scales have changed in the time between the original judgment and this one. This is also a quote from the European Court of Human Rights decision in Tyrer, where they invent this doctrine of the living instrument, where they talk about how the treaty is the convention itself is to be interpreted in light of present day conditions. In the case before it, the court cannot but be influenced by the developments and commonly accepted standards in the penal policy of the member states of the Council of Europe in this field. The ICJ says a similar thing. So if you look in Article 59 of the ICJ statute, it clearly says that there is no doctrine of precedent. Decisions by the ICJ are only binding on the states between them, in front of them, and the events, the dispute between them. So in theory, it cannot be, you don't have a doctrine. I don't know, is this shows my ignorance of continental Europe. Is the Ukraine a common law or a civil law system? Do you have a strong civil law? Okay. So you have a weaker system of precedent then, would be my understanding, than the common law. So this is something that, if I'd known that, I would have maybe made that a bigger point yesterday. The Jessup, and particularly the international rounds of the Jessup, are normally judged by Americans, and it is an American competition. By and large, I mean, I don't mean that Americans win it or that it's American biased. I just mean that a lot of the ways that the case is structured and the way that people think about mooting in general have these kind of common law traditions of precedent. What precedent essentially means is that previous decisions by courts are binding for lower courts and sort of into the future until, for some reason, the court might choose to change. In practice, whether there's a big distinction between how common law and civil law systems operate is a question that many books have been written about, and we don't need to get into that here. The point is just to note that the ICJ, in theory, doesn't rely on its previous cases as a strict doctrine of set precedent. However, and I recommend copying this quote out, as I said, you'll get the PowerPoint. In the preliminary objections, in this case, there's a really useful quotation, which weirdly I don't have the paragraph number for, where they say, it's true that in accordance with Article 59, the court's judgments bind only the parties to and in respect of a particular case. There can be no question of holding Nigeria to decisions reached by the court in previous cases. The real question is whether, in this case, there is cause not to follow the reasoning and conclusions of earlier cases. So that quote is useful both if you're an applicant who's seeking to rely on a previous case to say, well, the court has said we need to look at whether there are the reasons to depart, and there are no reasons because, and that is, of course, in itself a normative or a factual judgment, but that's another issue. If you're looking to upset the court's case law, if you're saying that the court should decide the law differently, this quote is really useful to show how the court has allowed this kind of development, temporal development of its law. International law is not something that's fixed. It has to change by the kinds of agreements that states are making. And it's very easy, for example, to say that judgments before 1980, for example, there wasn't the same awareness of human rights as a kind of enforceable mechanism and as an enforceable legal obligation that states had to care about. The kind of discourse of human rights is a relatively modern discourse. It's Samuel Moyn pins it in around the 1970s is when that really starts to pick up as a way of talking about international issues. So there are ways that you can challenge earlier judgments by the court by saying, well, actually, now that the way that states interact, now that the obligations that we expect upon states, they're not simply just not to go to war with one another. Now, there are requirements not to abuse human rights, not to allow damage in a foreign country, not to exacerbate health issues in another country, not to exacerbate environmental issues globally or in another state. So that quote can be really useful for showing how the court's interpretation of the law is open to kind of a number of different contextual challenges. So all this indeterminacy might leave you feeling lost. I mean, it makes most people feel lost. If there's no such thing as a fact that we can determine, there's no such thing as a law we can clearly determine, if all of this is open to argument, then what exactly are we supposed to do when we sit down at the computer and try and write our memorial? And there's this really interesting sentence. It's from the quote about article before, we read this before, about how the facts are ambiguous. And what the guide says is that Jessup judges want to focus on your team's ability to prepare and present good legal arguments rather than decide which team has the winning legal argument. What's the difference? I actually don't know. I'm going to give you an answer for how I would approach that question and how I would approach the idea of constituting what a good legal argument is. Now, I appreciate that the reason they put this in is that, for one, some arguments are unwinnable in the Jessup, or at least much more difficult to win. And the idea is that, you know, in practice, these cases would probably never reach the ICJ because some of them are just far too, they're kind of big violations, or they've been dealt with another way, or just things would never have progressed. It's not that often that you have, irony, I was about to say it's not that often that you have an annexation of territory because that was what my case was on, and then I remembered what country we're in, and that's not true at all. But the subject of Jessup cases is normally quite serious, and the point is maybe that, you know, states would be condemned much earlier on, or there wouldn't be as much of a kind of ambiguity about the legality of these actions in reality. But we still have this question. If we're not looking for a winning argument, but we're looking for a good argument, then we need to understand by what metric we think an argument is good within the Jessup. I want to take us back to David Byrne and the idea that the Jessup is a performance. There are two kinds of actor in the Jessup. There are lawyers and there are judges. And everyone is playing a role. So the lawyers will be trying to argue their case. They have to sound like they're international lawyers. They have to be making arguments that are legally correct, that are legally structured properly, that sound essentially like legal arguments, that are intelligible as legal arguments. But the judges are also playing a role, because the judges have to think about what the ICJ is doing, the kind of questions the ICJ would ask, the kind of things that the ICJ would accept as a legal or non-legal argument. Not all judges do this, obviously. Some judges just want to have a go at students. Some judges just want to prove that they're really smart. Some judges just want to sit quietly for 90 minutes. But I think, you know, ignoring those kind of realities, the judge should be playing the role of a member of the bench of the ICJ. So the way that I understand what a good argument would be that a pleader is able to effectively create an international lawyer's argument that would be accepted by the ICJ, or could be accepted by the ICJ. That would be the definition I would give of a good legal argument. There may be problems that would stop the ICJ from ever ruling that way, but the idea that the ICJ could at least consider that a legally formalizable argument, to me, is enough to get strong scores on this ground. So there's two things I want to take us through, two ideas of how to grapple with these questions. The first is the question of what it means to make an international legal argument. And I'm going to cite mainly from this book, which is called From Apology to Utopia. It's by this man, Martti Koskiniemi. He's a professor at Helsinki University, and he was a legal advisor for the Finnish Foreign Ministry. He's, I believe, argued before the ICJ and the ECJ and a number of other institutions. And he wrote this book. This was his PhD. It's The original one is much smaller, but it fell out of print. The new version from Cambridge is about that thick. It's about 600 pages, plus a gigantic index. The book is brilliant. It is difficult. It's not that difficult. He does a good job of making very difficult arguments simple to understand. It's comprehensive, is what I would say. He goes through every single possible step of his argument, which we'll discuss in a minute, and he applies it to many, many different forms of law. He applies it to customary international law. He applies it to the sources of law in general. He applies it to territorial disputes. He applies it to use of force. He applies it to, he just, sort of the first two chapters set out what the book is about, and then it's just a case of showing how that argument is correct. There are three key arguments to it, only one of which we need to worry about today. The first is that international law is not a separate system. People have a habit of talking about, well, let me qualify that. International law cannot be separated from political questions. It doesn't mean that international law is indistinguishable from politics. In fact, the entire point of From Apology to Utopia is to work out the structure, the deep structure of what makes an argument recognizable as a legal argument, as separate from international politics, as separate from international relations, as separate from philosophy, as separate from morality, as separate from ethics, as separate from economics. His question is exactly what the boundary is that makes something or rather what the language is that makes something a recognizable legal argument. The problem is that the content of legal arguments cannot be separated from these other issues. So he talks about the concept that international law has to separate itself, in the minds of lawyers, it has to separate itself from international politics and international principles. So by international politics, he means the idea of what states actually do. When we go and assess what states do on a day-to-day basis, that's kind of a descriptive account of what international relations are. International principles would be an idea of how we're supposed to organize the world. So whether we organize it around free trade, liberalism, Marxism. I mean, these are not, obviously Marxism is not one that comes up in international law that often, but the idea is that that is a way of seeing the world and a way of prescribing how politics should operate. International law has to distinguish itself from both of these things at once, but in doing so it automatically falls into the other argument. It cannot sustain the distinction between the two. So from the idea of describing politics, international law has to have some kind of objective criteria. International lawyers believe that what international law does is prescribe some kind of objective rule that is separate from what states actually do, and that we can prescribe state action by making them follow the law, or by prescribing international legal rules, sorry. On the other side, from principles, the law also wants to see itself as more subjective. It wants to extricate itself from questions of what somebody thinks the world should be like, and actually engages with the question of a universal system that can work. So the idea is that the law doesn't need to look at political perspectives or moral perspectives or philosophical perspectives, because what it's looking at is creating a structure that is objective, that can be applied again and again regardless of the circumstances. As you can probably see, and even I'm struggling to explain these without falling into the other trap, the two situations cannot coexist. So you can't pull yourself out of the actual actions of states without in some way by being normative, in some way prescribing an idea of what the good life is, how law should operate, how the world should operate. And on the other hand, if one wants to move away from pure subjective positions, pure philosophy, pure morality, pure politics, then you start to fall into describing exactly what exists already and locking down the existing circumstances of how states operate and how states buy into these legal arguments and agree to use them, essentially. So this is where the title comes from Apology to Utopia. The mere description of how states interact, if applied as a legal argument, only apologizes for what states already do. And utopia takes far too far seriously the question of justice, some kind of inherent natural law that pulls states into saving the planet, into peace, whichever way you want to look at these concepts interacting. So what Koskiniemi is interested in is how lawyers escape this trap and how they still manage to create something that we can all recognize as international law, even though it's filled with these inconsistencies and incoherencies. A point that we won't be able to develop today but is really interesting is that for Koskiniemi, the deep structure is not fixed by anything but the moment in history that we exist in and the historical project of international law in general. And in fact, his work after this book has been focused solely on history. So after he wrote this book, he wrote a book called The Gentle Civilizers, where he looked at the development of international law from the 1800s to the 20th century, and he looked at how a number of the ways that we think about international law were shaped by things like the colonial project, but also by a number of people who genuinely thought that they were kind of achieving the peace of mankind. That kind of self-belief of the international lawyer as the superhero, he wants to kind of trace that biography. And the current book that he's been working on now for 10 years goes before that. So it goes from the 1300s to the 1800s, and it looks to see how the idea of free trade and property has always been inherently tied into the legal form. We don't need to go into that too much, but the idea is that this kind of argumentation is a very 20th century modern way of speaking. International lawyers in the 18th and 19th century did not speak the same way. And that this could all change if we decide in a different way of organizing international relations, if we decide in a different way of, or if a different event occurs that requires us to view international relations in a different way, then the way that we talk about international law would probably be different. We'll get to that. We have some discussions on that later on. But just to kind of note that point. So yeah, this is essentially the quotation where he discusses the idea of the apology in utopia. So he says, to prevent international law from losing its independence vis-a-vis international politics, the legal mind fights a battle on two fronts. On the one hand, it attempts to ensure the normativity of the law by creating distance between it and state behaviour, will and interest. On the other hand, it attempts to ensure the law's concreteness by distancing it from a natural morality. And if a law which would lack distance from state behaviour would amount to a non-normative apology, a mere sociological description. A law which would base itself on principles which are unrelated to state behaviour, will or interest would seem utopian, incapable of demonstrating its own content in any reliable way. To show that international law exists with some degree of reality, the modern lawyer needs to show that the law is simultaneously normative and concrete, that it binds a state regardless of that state's behaviour, but its content can nevertheless be verified by reference to actual state behaviour. One of the principles of this book is that it's neither useful nor ultimately possible to work with international law in abstraction from these kinds of theories. So Koskiniemi comes up with the idea of ascending and descending arguments. And by that what he means is that if someone needs to argue for state behaviour, there are certain ways that you can work examples of state behaviour into a normative claim, where you can show that the way that states behave is not a sociological description, but is in fact grounded in some kind of normative ideal. So state sovereignty and territorial integrity would be one example of that. The idea that states can do what they like inside their territory and no one can tell them otherwise is quite a descriptive thing. That's something that states want to do. But there's ways that you can scale that up to a normative claim by describing, for example, how state sovereignty protects states from being pushed around by more powerful states. It prevents states being threatened by coups d'etats from foreign states. It prevents states creating dictatorships across multiple countries. It avoids things like the Cold War. I mean, I'm not saying these normative arguments are all correct or all of them are even believable in today's society, but the point is that from a description of how states want to behave, how states do behave, you can scale this up into some kind of normative idea. And it works the other way around as well. If one wants to advance a normative project, a moral project, an argument that something is the way things should be, there are ways you can ground this on the existing practice of states. So custom is a good example. You look at how other states behave, and you say that the state in question, because it didn't object to this, it must be bound by the same rules. It's still bound by the actions of other states. This is what states do, even though they're extending a new legal obligation onto the state in question. The book is brilliant and explains it in more depth. If you're able to track down a copy in the library, it's great. And I've also there's some citations later on for some articles you can read that discuss this concept. We'll skip that, it's too much of a other discussion. So what does this mean for us? Within the Jessup, to be recognised as speaking a proper legal argument, we also need to grapple with this question of utopianism and apology. And what it can be useful to do if you are the respondent, and I don't necessarily mean the respondent as the actual person, but the one who's having to defend an illegal action. Try not to just think about it as a question of you just saying what happened, or just saying that, you know, the law lets you do this and you did that and it's fine. If you can somehow ground your argument in a higher normative ideal, if you can make it bridge between this question of kind of what you've actually done and the reason why that kind of action should normatively be allowed, what kind of principles this does, or this enshrines, or in reverse, if that action was to be found illegal, what kind of bad consequences would there be? What threats would that pose for international security? And vice versa, if you're the applicant and you want to claim that there's a legal rule that, you know, should be enforced, or that this should be found illegal, that the actions of the respondent should be found illegal, if you can ground that not just in kind of ideas of justice and what you think is right, but actually ground it in even the actions of the state itself. If you can show that the respondent, you know, has signed human rights treaties, has done all these things, and then is choosing to act in a way that seems immoral, that seems inconsistent with the other actions it's taken in the past, then you present a way for the court to understand how your argument is actually based on what the state has agreed to. Again, this isn't something you need to do for every argument. It depends on what the argument is like, what the state of the law is. But it does, I mean, going back to some of the problems that you see competitors make, one of the worst things is when someone stands up and just makes a normative argument. So I think there might be examples, yeah. So your state has to apologize for killing civilians. One way that you can do that is say, well, the law doesn't regulate this, or that they're not civilians. And I mean, that's one argument, and it's an argument that you can make, and it might work depending on the fact. But another way to look at it is to say that there was a normative basis for those civilians' deaths. So actually, you didn't kill them because you're just a powerful state that likes killing people. You did it, in fact, to protect civilians. There was a normative idea of what you were, an idea of justice for why your actions should be legitimated by the court. In reverse, this was an example from last year's case. There was a question of extending compensation for states to take in refugees. Now, there's no law that supports that currently. But one of the things you could do was look at other existing principles of international law, such as the principle of due diligence, which is from environmental law, but it's currently spreading into other fields. And you can say, well, states have agreed to this principle. States use this principle elsewhere. Why is it different from refugees? And in that case, you've changed the argument from a normative one, that we should look after refugees, to one of actually this is what states already do. And what the opponent is doing is simply trying to cut between factual circumstances with no clear justification for why that distinction is made. Now, this is more, I mean, that's obviously a more, not philosophical, but you have to understand what's normative and what's apologetic and how this how your arguments oscillate between the two. But there's an article by Duncan Kennedy, which I'm going to briefly go through because it's quite complex. In fact, I would almost just suggest that you go and read the article. But he talks about the way that we argue in international, or in law in general. In fact, he's a domestic lawyer principally. There's a number of patterns that follow in legal argument. So he starts off by saying, when we think about a legal question, we can almost always come up with a counter principle that's equally valid. So territorial integrity, human rights. Territorial integrity is something that we can never violate. Human rights is exactly saying that the state can't do certain things to its citizens. And on the naked face of them, we can't decide which one is better. We have to know some kind of facts to come to a conclusion with them. What he does is takes these maxims, this maxim, counter-maxim pairs, and shows how you can use them to create certain kinds of operations within a legal argument. He identifies 7. I'm just going to zip through these because we're honestly running so short of time. But he shows how different deployments of these principles allows you to move a legal argument in different steps. You can almost predict the kind of response that you will receive by making a certain kind of argument. So one of them is denial of a premise. So, for example, pacta sunt servanda, promises should be kept, and the response to that would be, yes, that's a correct statement, but I kept my promise. So that creates a distinction between the norm and the event itself. But there are other examples. So the counter theory, that would be where you just reject the idea that they've stated altogether. So pacta sunt servanda and rebus sic stantibus, the idea that promises should be kept, or they should only be kept if the circumstances are the same. These two are on totally different grounds. Or you can refocus on the opponent's conduct. That's one. So you can say, innocent victims should be compensated versus, yes, they should, but the individual in this case did not get out of the way. We don't have time to do full justice to this, but I would recommend reading this article because it will give you some ideas, particularly for the oral rounds, of how you can fit different principles, different policies, different political engagements that you have to deal with into a coherent narrative. So yeah, here's some examples of argument bites you could make in international law. State sovereignty versus human rights, territorial integrity versus self-determination, self-defense versus peace and security. I mean, you compare peace and security against human rights, you compare peace and security against state sovereignty. All of these pairs are essentially, you can be compared or contrasted in different ways. And then, for example, yes, you could flip things. So you can say, the actions of the respondent have endangered peace and security, and the respondent can respond that actually our actions have enshrined peace and security. It all starts to hinge on what we mean by peace and security, what we mean by endanger, and how we understand these kinds of policy judgments. So, this is talking about how we make a legal argument, but we still haven't actually answered the question of who we're speaking to, who the audience are, and the kind of arguments that the ICJ likes. Now, we talked at the start about the idea that citation of cases is useful because the ICJ can follow its own case law. But it's also worth considering more in depth about what the ICJ is as an institution. So it's the principal legal organ of the United Nations. It's been established since 1946. It wasn't the first international tribunal, but it was, as being attached to the United Nations, it was this first kind of autonomous international sort of general court of international law. There were arbitral courts before, there were courts that related on trade and other kinds of agreements, but this was post-World War II, the sort of big project of having a legally enforceable international court. It was a successor to the Permanent Court of International Justice. I should say it wasn't the first one because it was a successor to the PCIJ, which was part of the League of Nations, but when the League of Nations fell apart, it was replaced by the ICJ. A couple of important things. As I said, only states can appear before the court, and can only draw law from the sources listed in Article 38. This has important ramifications for how the court views its own role. And to understand that, it's useful to compare it to other courts that have sprung up in its wake. So, for example, the iCourts research group has this map of international courts around the world, and they talk about there's 28 international courts working currently. Just some of the ones that you might know: the Court of Justice of the European Union, the European Court of Human Rights, the Inter-American Court, the International Criminal Court, and there are also quasi-judicial bodies like the Human Rights Committee. These courts are different to the ICJ in a number of ways, and we go through all different ways, but how many of you are aware of, are familiar with the European Court of Human Rights? Have any of you studied that before? Is that something that... So the European Court obviously has individuals come before it. The European Court hears hundreds of thousands of cases. Yeah, hundreds of thousands. I think we're now up to hundreds of thousands. And they have to deal with an individual who's had their rights violated by the state. And it has a more progressive way of looking at the law. It often wants to develop the convention to ensure that it's still protecting individuals, that individuals are not harmed by the state, or that the state is not allowed to do things to individuals just because of a kind of limited reading of the treaty. They sort of want to have a living body of human rights that are always protecting people effectively. By comparison, the ICJ is quite conservative because it's because it's only states that appear before it, and because it wants to find the law that is in place between states and nothing more. It's often stated how reluctant it has been to kind of extend the law beyond exactly what states appear to have agreed to. So this is, its predecessor, the PCIJ, has this famous dictum in the Lotus case where they talk about that international law is binding upon international law governs relations between independent states. The rules of law binding upon states therefore emanate from their own free will, and the restrictions upon the independence of states cannot be presumed. So the court cannot presume something that the states have not agreed to. Now, whether that's still true or not is another point, but the court has also made statements, similar statements. So in the Southwest Africa case, the court said that stated that it is not a legislative body and that its duty is only to apply the law as it finds it, not to make it. Similarly, in the fisheries jurisdiction case, it said the ICJ cannot render judgment sub legis ferendi or anticipate the law before the legislator has laid it down. Sergey, you're doing attribution tomorrow, aren't you? You're doing attribution? Or are you doing responsibility tomorrow? Are you talking about Tadic?
We mentioned Tadic today, and we'll come back to this.
Okay, so just you're aware of this, but the court has in Tadic, the ICTY, tried to extend the rules of responsibility, and the Bosnia genocide case that came after the court actually explicitly said that they would not follow the same standard, that the consideration of individual responsibility is different to the responsibility of states between states. That's not to say which version is better, it's just to note that the court kind of has this, the other states will have, other courts, will have different logics for the kind of conclusions they come to. And the ICJ's is much more grounded in exactly how states are agreeing to things, and it doesn't like to develop international law that far beyond kind of the conservative doctrines. There's a very broad sweeping generalization, but it can be a useful way to orient your arguments. What does this mean for the Jessup? You need to make your arguments palatable to the court. So you're unlikely to win by citing Marxist or feminist or third world scholars or approaches to international law. The more that you can ground your arguments in classical ideas of state sovereignty, state will, of previous judgments of the ICJ rather than judgments of more activist courts. Essentially, as I've said, I think, or maybe, yeah, giving the court the path of least resistance is one of the best ways to focus your arguments. So making sure that the court isn't having to say something controversial or that it's not having to create a new rule out of nowhere. If you can ground all of this stuff in things that the ICJ has affirmed before, or things that the state has clearly done before, or treaties that the state is a party to, it just makes it seem like a better argument for the audience. So yeah, taking these two concepts together, legal argument has its own certain structure, and the ICJ has a certain kind of argument that it is looking for. And these two things are self-reinforcing. So when we talk about the idea of a good legal argument within the context of the Jessup, I think what we need to do is think about how we speak intelligibly about international law, how we speak in a way that can be recognised within the rules of this kind of discipline, within this kind of professional knowledge, to take us back to what we were saying before. And the more you can focus on how your arguments connect, how your opponent's arguments challenge those arguments, and how you can learn to subsume and move around and even turn against these arguments back against the other side, the more that it becomes easier to not be so hung up on difficult cases or difficult submissions or difficult facts. If you work out how to kind of bend these things, I'm not saying that you take some Trumpian alternative facts doctrine, but the more that you can work out how to make this argument convincing by the rules of the game, the better you will do in the Jessup, I think. So there's a kind of reading list. I mean, you can go through these in your own time. Just some golden rules to summarize the last 3 days. Iraq. Please always write in Iraq, always think in Iraq. You might not need to speak in Iraq, but have in your mind exactly how all these issues intersect. Don't deviate from the compromise, but be attentive to exactly what it's saying, and particularly who said it. Don't ignore your opponent, because the bench definitely won't. Think critically about what you're being asked to argue, and think critically about how you are arguing it. And finally, the more that you can believe and inhabit the role of being an international lawyer, the more successes you will have in this competition. That kind of closes the lecture portion. Are there any immediate questions? I mean, I know there's probably a lot of confusion, but is there anything immediately I can clarify about anything in the last 3 days? Is there anything that I'm aware that we're now cutting into your lunchtime, and that's precious time, so I wouldn't want to go over. So I'll just give you a revision on tomorrow's exercise. Is everyone okay with tomorrow's exercise? Yep. So you just need to be able to stand here, talk for 2 minutes on any topic. You will have questions in the second minute. Don't worry about it. Just something that we can ask questions on. And I mean, you don't need to think about today's class. This has been much more theoretical and much more legal. But in general, what we talked about in the first two, the more that you can stick to a structure, the more that you can avoid having a speech and be able to move with what the bench is asking you by giving good answers while also making sure that you eventually reach the point you need to. Tomorrow should be fun. It's just to give you an experience of standing up in front of everyone and having questions before it happens on a Saturday and you're actually making a legal argument. Honestly, the Jessup is, I know I haven't really focused on this so much, but the Jessup is like great fun. It's stressful, it's hard work. Your family and your social circle will not understand why you're giving your life over to it. But the skills it gives you are incredible if you want to be a lawyer, if you want to be an academic, if you want to do research, if you want to be a politician, anything. I think the ability to grapple with some of these questions will really put you head and shoulders above anyone. And even if you don't compete on the team this year, or in general, for those of you that haven't been selected yet, even just having the experience in this summer school, it's honestly incredible that Ukraine can organise this. Your organising committee are incredible people with an incredible passion for this, and yeah, you're all super lucky to be here. I hope it's been enjoyable. If you have any further questions, my email is there. You can email me throughout the year, although this email will die in September, and I think this is what my email will be after that, but I'm not sure. Please keep in contact. If there's anything I can do to explain this or anything else or any help, I'm open. I wouldn't come and teach this class if the Jessup wasn't something that I think is worth doing and it can teach you a lot. And if there's anything more that I can do to help you get the most out of the Jessup, for you to be as enthusiastic as your organising committee and the people who bailiff and the people who've been working to make all of this work this week, if there's anything I can do to help you get as much enjoyment as they clearly have, then that's the smallest kindness I can do back. I think that closes it. I'll see you all tomorrow, but thank you for listening for the last 3 days. I hope it's been helpful.